Hello, my name is Jo Powis. I'm an associate in Reed Smith's London employment team. Today I'm going to be giving you an overview of the new reporting requirement for large businesses under the Modern Slavery Act. This is a really hot topic for large businesses at the moment. The Modern Slavery Act was passed in March 2015. The majority of the provisions in the Act consolidate criminal liability for slavery and human trafficking. However, in this podcast, we are going to be looking at Section 54, which, when it comes into force, will require large businesses to report annually on their efforts to ensure their business and its supply chains are free of slavery and human trafficking. First, I'm going to explain the obligation itself, how it applies, and when it will come into force. Second, I will look at some tricky questions that have cropped up on the interpretation of the obligation. I will then finish by looking at what companies should be doing now to prepare themselves for this new obligation. Section 54 of the Act requires businesses over a certain size to publish an annual slavery and human trafficking statement. Businesses have two options here. The first option is to publish a statement which confirms the steps the organisation has taken to ensure that slavery and human trafficking are not taking place in any of its supply chains or any part of its business. The second option is to publish a statement which confirms that no such steps have been taken. The second option is clearly the easy route. However, the government hopes that public pressure and scrutiny from shareholders and the media, together with the risk of reputational damage, will encourage businesses to take real steps to investigate their supply chains and publish details of their efforts. This is key to the success of the Act, as the only legal sanction in the Act for failure to publish, which is that the government may apply for an injunction to require publication of a statement, lacks teeth. To put some pressure on businesses to prepare substantive statements, Section 54 requires that the business's website homepage must include a link to the statement in a prominent place, making it easy for the public to find out what the business's approach to slavery and human trafficking is. The statement must also be approved and signed by a director. The government hopes that the need for board-level approval will make businesses take the reporting obligation seriously. Section 54 applies to all commercial organisations which carry on business or part of a business in the UK and have a turnover of a certain amount. Section 54 can therefore apply to non-UK registered companies. What is meant by carrying on business is currently unclear, and we're hoping for some government guidance on this. The turnover threshold was recently announced to be 36 million or more. Although this might seem like a random number, it is actually one of the thresholds in the Companies Act for determining the size of a large company. In consultation, it was estimated that the 36 million threshold would mean approximately 12,260 companies would be caught by the reporting requirement. Section 54 is currently expected to come into force around October 2015. At the same time, and unfortunately not before, the government is due to issue guidance to assist with compliance. The requirement to report is annual, and the government's response to the consultation suggests that the report should be issued at the end of the business's financial year. However, this hasn't been confirmed. Transitional provisions will be put in place so businesses with a financial year end in close proximity to October 2015 will not be required to report for the current financial year. Unfortunately, we are waiting for confirmation of the cut-off date for the transitional provisions. Indications we have seen suggest that businesses with financial year end dates around March and April 2016 will need to report for the current year, but this is not set in stone. So all businesses should be making preparations for compliance now. I'm now going to turn to considering some tricky questions regarding the scope of the requirement to report. The first is, what does slavery actually mean? The Act provides that slavery includes servitude and forced or compulsory labour, but doesn't include a full definition of slavery. Instead, it refers to Article 4 of the European Convention of Human Rights, which again doesn't include an express definition. European Convention jurisprudence refers to a definition of slavery from 1920s legislation, which says slavery is a status in which all powers attaching to the right of ownership are exercised. We expect that the same definition will be used for the Modern Slavery Act. How this definition should apply in the modern world isn't always clear, particularly in countries with different cultures and practices to the UK. This is something the European Court of Human Rights has had to grapple with in the past. Because of these concerns, the government has committed to providing a clear definition of modern slavery and examples of what constitutes slavery in the modern context in its guidance. What we do know is that servitude covers situations where a person is coerced to provide services and live on someone else's property without being able to change his or her position. Forced or compulsory labour is where someone is forced to work under the threat of a penalty. Those threats may be to expose the worker to authorities, withhold documents, or restrict movement or wages, for example. What is meant by human trafficking is also a bit more straightforward, as it is defined in the Act as arranging or facilitating the travel of another person with a view to that person being exploited. Examples of exploitation include slavery, sexual exploitation, and securing services by force. Human trafficking can be committed even where the victim consents to the travel. This reflects that the victim may be deceived by the promise of a better life, or may be a child who is influenced to travel by an adult. The second question on everyone's mind at the moment is what is meant by supply chain. The answer to this one is clearer, but results in an onerous obligation for businesses. Although not expressly covered in the Act, the government's clear intention is that supply chain refers to a business's global supply chain. In other words, it includes all companies in the business's supply chain, regardless of how far down the chain they are and where they are based. To understand why supply chain is defined so widely, it is helpful to look back at why the obligation to report was brought in the first place. The majority of the discussion in Parliament focused on the need to protect workers from developing countries who may not benefit from the same employment law protections as in the UK. An example from a witness to the Joint Committee was given of a business selling £45 t-shirts in the UK in circumstances where the t-shirts were made by people being paid 62 pence an hour and who were locked in the factory and not allowed out in case, as one owner was quoted as saying, they might come back hungover and not be able to work well the next day. In order to tackle such issues, which is clearly a positive step, the definition of supply chain must be global, resulting in a potentially onerous obligation for large global businesses to audit their own organisations and their global direct and indirect supply chains. Such companies may not be able to complete this process before the first reporting deadline, meaning the positive impacts of the Act may take a number of years to filter through. The third tricky question I'm going to cover is what is meant by turnover. As I have said, commercial organisations which carry on business or part of a business in the UK and have a turnover of 36 million or more will be required to comply with the reporting requirement. Although we await secondary legislation to confirm what is meant by turnover, the consultation papers provide some guidance. Firstly, it says that turnover will be the total net turnover of the commercial organisation, meaning the total amount of revenue derived from all sources after deduction of trade discounts, VAT and other taxes. This is the same as the commonly used definition of turnover from the Companies Act. The question then is whether companies have to look at group turnover to decide whether the threshold is met, or whether only the turnover of the organisation carrying on business in the UK is relevant. The consultation paper says the turnover threshold of a company carrying on all or part of its business in the UK will be assessed as including the turnover of all of its subsidiaries. Unfortunately, the paper doesn't say whether turnover of a company carrying on business in the UK also includes turnover of parent companies. Our prediction is that businesses will not have to look up the chain as well as down, but unfortunately we will need to wait for secondary legislation to confirm this. For franchise businesses, we expect that the turnover of franchisee companies would not be included when calculating the franchisor's turnover. What is helpful from a practical perspective is that the consultation paper confirms that where a parent and subsidiary are both required to produce a statement, one statement may be produced, as long as it covers the full business and the supply chain of the parent and subsidiary and is placed on both of their websites. Also, keep in mind that a business is only required to produce a statement for years in which its turnover is 36 million or more. However, if a business's turnover is around 36 million, once the business qualifies and has produced the statement once, it would make sense to keep this up, even for years where turnover dips below 36 million. I'm now going to look at what the statement should include and the practical steps businesses can take now to prepare. Companies ultimately have flexibility as to what is included in the statement. However, the Act lists 6 areas that may be included as follows. First, the organisation's structure, business and its supply chains. Second, its policies in relation to slavery and human trafficking. Third, its due diligence process in relation to slavery and human trafficking in its business and supply chains. Fourth, the parts of its business and supply chains where there is a risk of slavery and human trafficking taking place and the steps it is taken to assess and manage that risk. Fifth, its effectiveness in ensuring that slavery and human trafficking is not taking place in its business or supply chains, measured against such performance indicators as it considers appropriate. And finally, the training about slavery and human trafficking available to its staff. For businesses with large global supply chains, this is a lot to cover. Prioritisation of and focus on particular risk areas may therefore be key. There are a number of steps businesses should consider taking now to prepare for Section 54. Turning first to internal steps. Businesses should consider introducing a new policy regarding slavery and human trafficking, or making appropriate amendments to your human rights policy or code of conduct to deal with these issues. The policy should set out that the business has a zero tolerance of slavery and human trafficking, and set out what steps the business is taking to tackle these issues. Second, think about expanding your whistleblowing policy to cover any concerns about slavery or human trafficking. Consider providing training to employees regarding the relevant policy covering slavery and human trafficking and how to make disclosures regarding any concerns. Order your practices for checking all employees are paid at least the minimum or living wage and have the right to work. Appoint someone to be responsible for receiving reports of issues relating to slavery and human trafficking. And finally, appoint someone to be responsible for overseeing the production of the statement. Now, looking at steps you can take in relation to your supply chain. First, update template commercial agreements to include an obligation that suppliers will comply with the Act and ensure that their suppliers and subcontractors will too. Consider preparing a code of conduct which all suppliers are required to sign up to, or check your existing one to ensure it adequately covers slavery and human trafficking. Consider what steps the company would take if it discovers a supplier does not adhere to the terms of the contract or a supplier code of conduct. For example, requiring the supplier to provide a remediation plan and take corrective action, and/or termination of the engagement. Make this clear in the relevant document. Consider whether any changes need to be made to supplier due diligence before an engagement is entered. For example, you may wish to start asking suppliers about their own practices on slavery and human trafficking as part of a questionnaire. Questions may cover whether they have policies consistent with the company's policies, what training they provide to their employees on the issues, and whether these principles are cascaded to their suppliers. Consider how you will use this information as part of the decision-making process. Finally, identify high-risk areas in the supply chain and consider prioritising an audit in those areas. Businesses should also keep an eye out for the government guidance which is due to be published in October and which should provide further detail about what a good statement should look like. For any further questions on the Modern Slavery Act or any other employment issues, please do not hesitate to contact a member of the Reed Smith employment team.